Let's take another example. In this case, the injured person claims that they have a back injury, and they go to a doctor and they treat, and there's reports written and there's some medical records, and let's say that the person who was responsible for the accident has a $50,000 policy. Well, contacting the insurance company and making a demand for policy limits under those circumstances with no medical records, no reports, and no information, and giving them a short period of time and not cooperating with them may not be unreasonable for the insurance company to reject the demand, especially if the insurance company asks for more information. Lawyers should cooperate within reason with insurance companies when they're making a policy limits demand. It's not automatic. And if you must go to trial, and you must get an award in excess of the policy limits, because if you don't get that, then there's never going to be a subsequent lawsuit. Now, in cases where there is a judgment in excess of the policy limits, and you believe that the refusal of the insurance company to accept a reasonable demand within policy limits was unreasonable, you now have to go about filing a lawsuit against the insurance company. But simply filing a lawsuit against the insurance company isn't enough. You usually either have to have the cooperation and dual representation of the policyholder. This means the person you just sued, you need to work with them in suing his or her insurance company, or you need to get what's called an assignment of rights. And this is very tricky, and where a number of lawyers can make mistakes is how this subsequent lawsuit proceeds. Because your client, the injured person, may now have a $2 million verdict with a $15,000 policy, but in and of itself, that's not enough to go after the insurance company. You have to take either assigned rights from the other driver, the policyholder, or work with that other driver in suing the insurance company. Then and only then do you have a shot at establishing that the refusal to accept the demand within policy limits was unreasonable, and that the insurance company should be liable for all the damages. One of the reasons why popping a lid on an insurance policy is confusing to people is because lawyers have to understand that the insurance company never has an obligation to the injured person in most cases. Their obligation is to their insured. It's to the person who bought the policy who was responsible for the accident. And their obligation to that person that's their insured is where the duty arises. So it isn't whether or not the insurance company is injuring the injured person further by refusing to pay, it's whether they're exposing their policyholder to excess liability above the policy limits. Because when a lawyer makes a demand to settle within policy limits, the insurance company's obligation is to evaluate whether they're doing everything they can to protect that other driver, to protect their insured. And only when they breach that obligation do they have the potential of being sued for bad faith and punitive damages. You need to bring in competent counsel who understand insurance bad faith. You've done a good job to get a judgment in excess of policy limits. Now you're a witness. Now you need to have somebody in your corner who actually can bring that lawsuit against the insurance company, because that's a much more difficult, much more tricky lawsuit than the one that was originally brought. You've established the damages, you've established the liability, now you have to establish that the insurance company was at fault.